Go ahead and introduce yourself to the world.
Oh, how exciting. My name is Sean Lynch. I'm the Director of Review Services for Ricoh Canada. I am a lawyer and left the strict practice of law about 5 years ago to do what I do now, which is oversee the managed review services for Ricoh in Canada.
The strict practice of law.
Strict practice of law.
What does that mean?
Well, considering that in Canada, it's very similar to the way it is in the US, if you're not practicing law, you can't provide any legal advice. If you're part of a corporation, you can't provide legal advice for the profit of the corporation. So we might be a group of lawyers that all work to service our review clients, but we don't actually provide any legal advice or opinion. So we're all lawyers working for lawyers, just not providing any legal advice.
Does that make sense to you that that's the arrangement? Is that a good one? I'm not.
No.
That's not loaded. That could be that. I generally come from an orientation where I don't challenge the status quo. While oftentimes I think there's a lot of logic behind the status quo. You just have to you never thought about it because you never had to justify it because it is the status quo. Do you like the status quo?
I think there's logic to it. If you look at the reasoning behind why corporations aren't allowed to profit off of lawyers, it's because law is supposed to be something that, for lack of a better word, is fairly sacred. The way we treat privilege, that there is supposed to be a special, fully trusting relationship between a client and their counsel. You don't want to impregnate that with any sort of a goal for profitability. Whereas a corporation is usually driven by, for the most part,
Which
not all,
is shocking because
they're driven by profitability.
Law firms have a profit of 40%.
Sure, usually.
That's the fake number, but it's still a very high number.
But I think the difference there would be that the law firm still has legal principles it has to adhere to when it's practicing law, whereas corporations don't have that same sort of, let's say, higher level of requirement. So that's why I think for the purposes of separating out legal advice from, let's say, call it legal work or work related to the practice of law, I think that makes sense because you do want to keep that delineation between providing confidential, strict legal advice to your clients versus engaging third-party providers like Ricoh's review services to assist counsel with their work, which is what we do. So we get involved when counsel has sort of reached their threshold for how much they can handle internally. And, it could be anything. It could be 500 documents. It could be 5 million documents, depending on the size of the firm and the ability of counsel to handle that. And what we do is we come in and we say, okay, we'll take that off your hands. You give us the instructions. You provide us a legal memo. We follow your instructions to a T, and we then hand you back exactly what you didn't have the time to do. So it's less expensive, it's faster, more efficient, it's fully defensible, and it makes corporate counsel and any lawyer's job really a lot easier, and they can practice law. They don't need to worry about going through discovery like they might have to
practice
do another way.
law.
But they can focus on practicing law.
What is practicing law? What is that? I hear that a lot.
Yeah.
Let's let the lawyers focus on what they really. What should the lawyers be focused on? Because you're the perfect person to answer this because you were a lawyer and you've been on both sides of this. Yep. The corporate legal services side and the lawyer's side. So,
I think that what clients want to see out of their counsel is higher level legal work. And by that I mean they're not sitting in a chair reviewing documents that might not need to be looked at. They're not trying to sort relevant from not relevant. They're focusing all of their time and usually considerable cost on reviewing documents, providing memoranda, advising their clients on things that they have to do, on things that are important to the overall legal process. Whereas if they're spending a lot of time and effort, cost, etc., doing work that is, let's call it lower level legal work, where you're just sifting through a mess of data, counsel doesn't need to do that. There's no reason for them to do that. More importantly, there's no reason for their clients to pay top dollar to their law firm to be doing that. That should be something that's outsourced to a legal services provider that, provided they're given proper instructions, can do it for
Is the
counsel.
only reason to go to a provider, is it only for cost savings?
No. I don't think it's for cost. I think cost savings is one parameter that is overall important to a client and to a law firm. Mm-hmm. It's also defensibility. Law firms, I think, are very good at practicing law. They're not necessarily geared to handling large amounts of data or conducting a document review or advising their clients on proper e-discovery processes. That's not to say that there aren't great e-discovery lawyers out there, but that's more the e-discovery in court process.
Well, what, you ever think about, like, should e-discovery providers, should they just be law firms? Meaning, should they be under? Is that? And I'm not. Mm-hmm. I don't ask that as if it's assumed that's like a conversation that's necessarily being had in the industry. But is it something that you've ever thought about? Like, and I ask you. Yeah. Having been on both sides of this,
there are law firms that practice nothing but e-discovery. So there are law firms that are in Canada, there are law firms in the U.S. that do what I do, but because they're a law firm, they're able to provide legal advice. At the end of the day, do I think that makes a functional difference between the process and what the client gets out of it at the end? No, I really don't. I think it comes down to what people do you have doing the work, what does your process look like, and what experience do you have? Because a law firm can get up and say, well, we're a law firm, therefore we're going to do things better because we're a law firm. And an e-discovery provider could get up and say, well, we're going to do it better because we're an e-discovery provider. I don't think that's as important as what is your people and process that you have going into this entire thing. If you don't have that balance right, if you don't have the expertise, if you don't have the people handling it to provide a good product, whether you're a legal services provider or a law firm, it doesn't make a difference. You still need to be able to deliver at the end of the day.
You need to be able to deliver. So one of the interesting things now that's happening in the industry, and something I've been writing about for a few years, and obviously relevant to both of our sponsors here, Heretik and Gravity Stack, is the expansion from e-discovery to where else should we apply the same discipline, rigorous technology, rigorous process and workflows to other fields. And I know that's something that Ricoh has thought about. Ricoh Canada has thought about quite a bit. And you were, when you practice as a litigator, I assume.
Yeah, I did.
Right, but now we're seeing outside of litigation the application of a lot of these disciplines. How are you all thinking about that?
I think that we're going to see legal service providers move further upstream with data. So it's no longer going to be an event.
Are we going to call them legal service providers more than e-discovery?
I think so. I think legal services is going to be something that encompasses the both e-discovery, something like that. Exactly. Moving farther up the chain, so you have legal service providers getting involved with the data at the start rather than in an event-based world. Like right now, it's very event-based. Someone gets sued. A corporation buys another corporation. There isn't really a continuum of the involvement of legal service provider with the law firm, with the corporation, so that data is being properly managed at all points. So that when the litigation does come up, even though it is an event, it's something that can very easily be handled because there is so much more involvement of that third-party provider earlier on in the data. So hopefully, we'll get to the point where analytics is involved at an earlier stage, where you're already processing data as it's made rather than collecting it and then bringing it into a place where you then process it and then move down. Again, that event-based situation, it's a continuum of the way we manage data with the goal of reducing it and controlling it.
So an event-based work as opposed to continual engagement.
Exactly.
And what I heard someone say recently, it's not vet the business, it's run the business.
Yeah, that's a good way of conceptualizing it. Yeah, exactly. Yeah.
What are the challenges from an e-discovery provider's point of view of moving from one to the other? Is it just as easy as saying, okay, let's just kind of like spread? I imagine it's trickier than just saying, all right, we're moving from event-based work to continuous engagement.
Yeah, it's not going to be a quick like flip a switch type of process. But you would assume companies in companies like you, like Ricoh Canada, are going to be the ones who need to experiment with that and figure it out. Yeah, absolutely. And I do think that we're as a group of e-discovery providers, legal services providers, there is a consensus that the software and the software that we have access to at the moment and the movement towards cloud-based computing, so moving into Azure, moving into Amazon's AWS, moving into those type of environments, does have a forward-looking eye to controlling data at the start, like controlling data at its creation, and making sure that that you're controlling it from the beginning of its life to the end of its life. Whereas right now, again, very event based, where we're going to say, well, we have data parked over here, we're going to go collect that and find out what it is. Whereas with where we're moving, you're always going to know what everything is and where it is. So it's the control change. And as corporations, law firms, as we as an industry become more comfortable with utilizing that type of technology, I think that we will slowly make the move to cloud-based, analytics-based data management as opposed to what we do right now.
Right, interesting. So in other words, if I'm hearing this right, this isn't just about the move from e-discovery, from litigation to contracts. This is about the idea that, listen, the wrong way to do this is crisis management.
Yeah.
The correct way to do this is proactive data management.
Absolutely. So that's why you're seeing a lot of dark data investigations becoming
Dark data.
So data that you don't know that you have it. You don't know what you don't know. For example, you might have, for a very simple example, you might have, let's say we all have backups. We use OneDrive, we use Google Drive, whatever we might use. And we have a backup that we created at one point. And then for whatever reason, we switch phones, we make another account, we do something that creates another backup. So we have one backup, we have a backup of the backup. And that first backup that's just sitting there, we kind of forget about.
Mm-hmm.
So there's a bunch of sensitive material on the one we're currently controlling, so our new phone, our new laptop, whatever it might be, and we delete the sensitive information that's there. But we forget that we have another backup over here. That's the dark data side. You don't know, either you've forgotten about it, you've put it somewhere else, someone else created a backup that you don't know about. Trying to map down to that data that you don't know you have, that is where we're going right now. For the purposes of moving the data that you need to have and need to control into an environment where you can see it all at once. So into that cloud-based environment, into an environment where analytics can help you from the start rather than at the finish.
Put on your lawyer hat for a minute. Does that mean that potentially we could get to a point where we quash disputes before they even happen? So that, in other words, as opposed to saying, "Oh, we just got sued. Let's find out what happened." No, we kind of proactively say, "Listen, I think there's a real strong possibility we're going to get sued over something, and I'm telling you right now, we've got some shit on the record that ain't going to look too good for us."
Yes. One of the things that I talk about a lot, even when I'm talking about document review, is risk management. And it's not something that is necessarily discussed when you think about document review. So you're like, well, it's not really a risk management exercise, and I disagree with that. Because you need to know when you're making a production, when you're involved in discoveries, when you're disclosing anything, you need to know that you've produced everything that's relevant to a particular matter. Mm-hmm. And if you haven't produced everything, why you haven't produced it. And if you know why you haven't produced it, what's the risk associated with not producing those documents? Are they likely highly relevant, or are they likely kind of borderline relevant? And if you can't explain that, then you have opened yourself up to risk. And I think that flows very naturally from your line of reasoning, that if we get to a point where we know where our data is and we're looking at it from an analytical perspective, if you're looking at some of the latest, the software that, for example, that Heretik has just come out with, where you can and Relativity for that matter, where you can find specific things in contracts, in a document, that indicates that there might be a problem. And if you're doing that at the start, because all of your data is well managed in an analytics-based cloud environment, you can see that in real time, and you can spot the potential risks much earlier. So again, run the business, not risk the business type of situation, because you're not dealing with an event where you find that document later on, 5 years after it was created. You can find it when it's created and manage that risk more appropriately. Exactly.
So I constantly have young attorneys emailing me saying, I want to get into legal tech. I want to do something. I don't want to be a lawyer anymore.
Sure.
Someone who's made the move from law to now e-discovery, and as the e-discovery industry shifts over to what we're calling more continuous data management. Mm-hmm. what's the best advice that you could give to someone, even at this law school stage, is, listen, if you're one of those people that's not going to want to live the life of trying to make partner at a big law firm, which is, it's like trying to win the lottery, but takes a hell of a lot more work.
Yep.
What advice would you give? Because I tell people I'm the worst person to ask. I left my law firm on a very impulsive whim. I struggled for years before I was able to make it out of that. You don't want to follow the path that I took. That's it's like asking someone who just jumped off a mountain and somehow landed in the water. It's like, hey, how did you do that? It's like, nah, don't do it. I'm not going to do it again. Neither should you.
So first and foremost, if someone comes to me, maybe they're not even in law school, and they say, "Oh, I really want to go to law school," I usually ask them, I say, "Why?
Why? Right?
What is your reason? Do you love the idea of being a lawyer? Are you just enamored?"
I just hit him with go fuck yourself.
I try to say I don't recommend going unless you really, really want to do it. If you're already in law school, congratulations, I guess. If you're
congratulations, you have minus $150,000.
Even more than that now, I think. But yeah, if you're in a situation where you don't necessarily think you want to practice and you want to get more involved on the data side, one thing is law school does one important thing that I think often gets kind of brushed under the rug. Law school teaches you how to think differently. So there's value in that. There's value in being trained to be a lawyer, but
okay,
if you want to get into the technology side of things, then you probably shouldn't have gone to law school in the first place. You should have prepared yourself for something that you actually wanted to do and liked to do. So I think you're not necessarily stuck, but I would suggest take what you can from what you learned being a lawyer from practice and apply it to essentially what we do now. I mean, the legal industry is expanding, I wouldn't say exponentially, but it is growing. It is growing at a rate not a bad
industry to be in.
No, it's not a bad industry, especially when you're on the technology side.
I'm old fashioned. I'm a billable hour truther. I don't think that law school needs to be dramatically changed because we're producing people that are not ready for the workforce. I think it's very possible to your point, it's possible to learn how to, to set up to use spreadsheets to leverage information. A lot of this kind of the more tactical menial work you can learn.
Yeah.
And I think that more than you talked about, a way to think. I think that's true. I think law school, for me at least, the thing that I took the most from law school is understanding the importance of fiduciary duty. And I don't believe that can be taught in a technocratic method. I think it has to be something that you really hit over the head with a lot. And I think I'm not saying that law school needs to be 3 years and that it needs to be only doctrinal courses. That's silly. But I don't think we need the massive overhaul that some would say, where we need to have University of Phoenix style law schools that are that to me is silly. And I do think that I was saying this yesterday. Are you a Harry Potter reader at all?
Oh yeah, sure.
All right, so in Harry Potter, do you remember who handles the gold?
Oh yeah, the goblins.
The goblins, right? And the goblins don't have necessarily a new high-tech way of handling the gold. It's because when we get closer to the gold and closer to the possibility of losing our gold, we say, bring in the goblins, right? I don't know. We don't want a new way to do this. We want the oldest. We want those old goblins doing this. So I think that there's something to that. Listen, this has been really fun. I'm glad we got a chance to catch up. I think you have a really unique perspective. So many people who are on the e-discovery side really never practice law. If they can't talk about that transition. Yeah. I think that's a really salient. It's a really salient point for attorneys who are looking at their career prospects and kind of thinking about it how to think about what the dean of my law school talked about a graduation as a non-linear career. Yeah. And I think you're really helpful to people who are thinking about that and helpful to thinking about where our industry is going. So thanks for coming and hanging out. I really appreciate it.
Appreciate it.